Welcome back, everyone. Welcome back to the Lawcast. I am Chris and that is Melanie Fuller. We are both solicitors here at MJT Law, and we are back in the office. We are
back in business. Yes, the last two have been
virtual. On Teams.
Now we're here, sitting on the sofa again, and far away from each other.
There is,
for those who can't
actually
see,
some stimulation behind us, not just the white wall that I had.
I tried very hard to have, you know, some background interest.
Some sort of stuff going on.
I think even my bees featured in one of them.
They did. All the pets.
They're all alive and kicking, buzzing.
Yes, as I've always said, the good thing about Teams is you find out just a little bit more about the people you work with.
Just a little bit more.
Just a bit more than you'd ever find out. But what's going on?
Right, there was a case yesterday. 7th of September, so not yesterday, case a few days ago. 7th of September, application for unfair dismissal, remedy, application for costs.
Oh.
Really interesting. So those who don't know, costs in a unfair dismissal or general protection space is near on impossible. The levels that you have to go to in order to get costs is high.
We pretty much, our advice is generally
you're not going to get
it. Don't expect it.
Yeah, this one might be done on an indemnity basis.
Wow.
For those who are watching or listening and don't know what an indemnity basis is, it means the actual costs the lawyers charged, not the court scale or some other type of costs. The actual costs, which are always so much higher than what we call a standard scale. So this chap was working at Iron Mountain and he was dismissed.
Yes.
It was an interesting case, and this is the reasons why the application for costs was made. The decision was made in December 2014 that his dismissal wasn't harsh, unjust or unreasonable.
Okay, so he's lost. He's lost.
And there were a bunch of problems with the way the matter was run. It says that the applicant didn't comply with amended directions and wrote to the commission things like, I am still psychologically unfit to write a response. Proof of my medical conditions are attached. If the Fair Work Commission is unable to grant me further extensions, I prefer to present in a tele-hearing on the 11th of May.
Okay.
And finally, please note that for a request for patient approval for psychological treatment has now been received and was verbally confirmed by my case manager, and so on and so forth. So a certificate of capacity was attached and he was meant to turn up to this teleconference, which he did not. Yes.
So this was his idea, though.
He said, I will turn up to a teleconference if we can't get an extension, and then he says, due to my increased medical condition prevailed, I am unable to participate. He apparently said this an hour before the hearing.
So they've prepped.
Everyone's there.
That people put time aside.
The commissioner's read all the material. Everyone's ready. Okay, so an hour before he said he can't attend. So he didn't attend. And he says at the hearing, Ms. Price appeared on permission for the respondent. I determined that the hearing should still proceed in the absence of the applicant.
Ooh, that's
on the basis that the medical certificates provided by him did not substantiate any incapacity which would explain his failure to provide a response to the application and to participate in the hearing. So really interesting stuff here.
So presumably he's given a general medical certificate, not
unfit for work type stuff.
Which he is unfit to be able to provide a response in his.
Yeah, this is going really badly for him. He feels like this medical condition is severe enough not to attend these hearings, but the commission has made the decision that the information in it didn't provide that backing.
Yeah.
Really interesting. So they made a decision and found in favour of the respondent. Now I can't tell you whether or not the commissioner would have found in favour of the applicant, whether the applicant was there, but there is some language about that. So this is the reason why I'm saying to take, because it's a little bit spicy.
Because I suppose for everyone out there, this is now getting into a space that the commission doesn't really
they're not really talking about
trend
this stuff.
Into at all.
So the background to the cost application. Now, it says here the relevant facts are largely uncontroversial. And look, I need to say also, it says at the end, it says, ultimately, of course, all these matters are not terribly important or relevant, as they are not the reasons for the applicant's dismissal. So just talking about a lot of these things. So at the time of his dismissal, he hadn't attended work for 15 months on medical grounds. 15 months.
Significant amount of time.
It's over a year. And he was notified that his employment was terminated as he had demonstrated no capacity to work in the foreseeable future. Prior to his dismissal, he had raised a number of grievances against Iron Mountain, and in 2019 he was diagnosed with a major depressive order and took a period of sick leave, and started discussions about all that.
Yeah.
Then in October 2019 he filed a general protections application. In that application he sought orders to reopen grievances arising out of his employment. The matter proceeded to conciliation but didn't reach a conclusion at that point. Now, so we've got a guy who started work, then had a bunch of grievances while at work, and then stopped turning up after a period of time. But in between there, he filed a general protections application. It says, and then he was terminated, and then he filed an unfair dismissal. Following a conciliation conference, Iron Mountain offered to resolve the unfair dismissal proceedings and pay 5 weeks notice and 8 weeks severance, being $12,000. The offer was rejected. This is all written in the decision. And this would have been because it would have been relevant for the costs application. At pre-hearing directions. Now, for those of you who don't know, during an unfair dismissal application, you get, the first thing that happens is you conciliate in front of a conciliator, essentially the first thing. Yeah. Then there's a whole pile of documents that get passed between the parties that were ordered by the commissioner, and then the commissioner holds a mediation of sorts, a conciliation of sorts, right before, about a week before the hearing, to see if they can basically stop it. Really bring it to a head.
Last opportunity.
Last ditch
attempt
attempt
let's talk about
to get a third party involved to see if we can resolve these matters, and that's where we're at here. So the pre-hearing directions, Deputy President Sams, before Deputy President Sams, Iron Mountain offered to settle the matter for a sum of $15,000, so more than the last one. He agreed to the offer, and a deed of release was provided in similar terms, and then he refused to sign. So
he's got a deal, he's got the deed in front of him, nothing particularly wrong with the deed, he's had a second thought, and he presumably wants to go ahead with it.
Matter goes ahead.
Yeah.
We know it goes ahead, because he didn't turn up to it. And it says, to observe the applicant was a very difficult employee to manage is truly an understatement. Wow. He was uncooperative and demanding. He demonstrated little understanding or willingness to comply with day-to-day ordinary expectations of his responsibilities and obligations as an employee. Consistent with his contract of employment, he refused to work at certain company sites or with other people who he perceived to be unsupportive of his views. Every reasonable workplace instruction he disagreed with met with a formal complaint. Can you imagine?
Wow.
When all of his numerous historic complaints and grievances were investigated and found to be either resolved or having no merit, he simply refused to accept any outcome which he disagreed. In my view, not even the wisdom of King Solomon would have convinced him his grievances were, for the most part, without substance.
Wow, that is as clear and as disparaging as you get from a commissioner ever.
It's a fascinating case, and for those of you who are interested, it was handed down on the 7th of September, and you can read this for yourself. It's 9 pages long.
Yeah,
it's fascinating. And then they say, like I said at the beginning, ultimately all these matters are not terribly important or even relevant, as they weren't reasons for the applicant's dismissal. But you know, they went through the costs and made the decision that, based on, you know, all that criteria that we have to think about, perhaps it shouldn't have been.
So they got the costs?
Got the costs, and it says, like right at the very end, it says, the unfair dismissal claim was, in my view, manifestly untenable, and it ought to have been reasonably apparent to him that his application had no reasonable prospects of success.
Wow.
In my view, a reasonable person would have determined the application had no reasonable prospects of success, as his employment was terminated on the basis of long-term incapacity and refusal to work. This is supported by medical evidence he filed on his own claim that he had no capacity to work. And in addition, his doctor's evidence, which the applicant accepted, that even if he was medically fit, he wouldn't return until his past grievances had been resolved to his satisfaction.
So unless they rolled over and did everything for him, he just wouldn't.
Unless they agreed with him. Yeah, whatever his grievance was. Remember, he wasn't because they didn't agree with him. He didn't believe it to be true. So yeah, irrespective of his actual understanding or state of mind in bringing the application, the question of whether it should have been reasonably apparent to him that his application had no reasonable prospects must be viewed objectively from a viewpoint that is clear and that the application was without prospect. So yeah, they've ordered on an indemnity basis, but there is a question as to what those invoices are going to be. Mountain, this is the interesting thing.
Mm.
Through all of this, Iron Mountain provided 3 invoices from Susan Price Legal in relation to unfair dismissal claim, totaling $18,000.
18. Well, that's not entirely surprising. There's a lot of work done in that.
Yeah, but I think 18 is quite low.
I was just about to say, I think that's, yeah.
I think that's very cheap.
They've done that on very cheap.
They've done that. I don't know what, I mean, there may not have been vast amounts of evidence. But yeah, but it just says Iron Mountain is directed to provide an item of schedule of costs according to Schedule 3.1 within 14 days. I'll finalise for a cost order. Mm. So this might not be the end. This could have been for something, and then they're talking about something else. But I guess the moral of the story is, sometimes it can be quite cheap to go to the Fair Work Commission all the way through to a hearing. For those of you who don't think $18,000 is cheap, I would definitely start shopping around and figuring out what the actual costs might be.
I think you won't find too many lawyers
who are willing to say it'll be less than 20 grand.
Yeah.
And also this fascinating concept that your employee could be so obstructive that they have no reasonable prospects for success.
It was so apparent that you were just a terrible employee.
Really obstructive employee.
Really obstructive.
Wouldn't agree, wouldn't do anything.
That being fired was abundantly clear. It should have been abundantly clear to you.
Plus he hadn't turned up for 15 months. Don't forget that.
Well, I suppose it's not too dissimilar to if someone does something, so obviously capable of being fired for,
stealing on video, that sort of thing.
And you knew the video.
You knew it was being videoed.
You admit in the video. And
this is true because he not only said that he couldn't turn up, but he agreed with the doctor's decision that he wouldn't have been able to turn up.
Mm. I wonder if this... I quite like seeing these types of decisions because we've spoken about this at length, and if you haven't sort of seen our last few podcasts, we've spoken about it, I think, which is sometimes I feel as though the current regime
It's a little bit broken.
It is a little bit broken, and it makes it too easy to get in, but too hard to win. And
you mean for the employer or the employee?
I think it's actually kind of equally both of their issues, because if you're an employer, for example, it's too easy for a ex-employee to bring an application against you.
Right, and drag you into a very expensive legal claim.
Exactly, drag you into a process.
Which may not have any merit whatsoever.
Yeah.
And most of them fail.
Most of them fail. And although they got their costs back, that is...
unusual, which is why I brought it up today.
Very unusual. So you're dragged into a process which you also don't have the benefit of deciding whether to continue or not. You don't really get that ability to leave if you don't want to.
No, you have no ability to get out, even if your employee has been exactly like this, completely obstructive throughout his entire employment.
Exactly.
Really fascinating stuff.
And then on the other hand, for the employee, it's great. It's easy to get in. It doesn't take very hard, but it's very difficult to win.
It is hard to win. especially if you're on your own when you've got no money. It is a very interesting system. I do find that employees tell me when I speak to them, you know, the odds are stacked against them. The Fair Work Act is not in their favour, it's for the employers. And I have just as many employer clients say to me, you know what, there is no win here. It is too hard to get rid of a bad employee.
I see it as everyone is losing in this situation.
It's a very interesting...
Rather than everyone winning, everyone's losing.
Well, certainly an unfair dismissal, because the quantum is the damages or the money one might receive at the end, is so low it makes no sense to file an unfair dismissal to begin with.
And you sort of think they have to know that. There has to be in their thought process when they were drafting these legislations that...
Maybe no, no. So this was a new regime back when it first started.
But they certainly know now.
Yes, decade later. We've been talking about this for some time now.
That, you know, for the most part, for most employees and, you know, for most your average wage, it's not going to be worth.
So what is it? Is it I was right after all, I got those guys? Is it that then? Because that's an abusive process too. If the only reason why you're starting it is to get them, that's also an abusive process.
Yeah, and you have every chance of leading yourself into a cost issue. But we see it all the time.
We do see it all the time.
You know, people who, it's all about the principle.
It's the principle of the thing.
But I think...
But it's more than a principle of the thing. I want to get them back. It has to move past the principle and into revenge. And that's where... You fall into those cost jurisdiction traps.
Yeah, commissions and courts don't
abusive
particularly
process.
like that too much. But it's
fascinating language. Solomon himself could not have convinced.
Isn't it nice when... I mean, for everyone out there, we read stacks of cases and the language is pretty similar. I mean, there's different commissioners, different judges, and they're all slightly different.
Yeah,
but
it's quite dry.
Quite dry. But every now and then they put little gems.
There's quite a fun little case there.
Just a little statement which is completely different to what they usually write. You know, something a lot more colloquial, a lot more conversational.
Just kind of fun. Do you remember the Da Vinci Code? For those of you who don't know, the Da Vinci Code was written. I can't remember, someone wrote it. Apologies, Da Vinci Code writer. And there was a dispute over whether it was unique material or not. And it went to court, and the judge who decided on whether it was a unique piece of literature or not put in it Da Vinci Code.
Really?
Yes, he did.
Really? As in the coding for which the book is all about?
Yes.
Some of the decision is in code?
Well, it wasn't in code. You could read it and see the code. And you could... It's because it was in some sort of crypto code. Yeah, it was...
Just interesting.
Just really fun. I mean, I don't know how much extra time he spent doing that, but that would have been actually quite a lot of fun.
It would have been a lot of fun.
Hopefully he wasn't charging someone for that privilege, but, you know, he's doing it in his spare time. But, you know, if you apparently... I haven't actually read the decision myself, but it was well publicised that there was a code within the decision, which was quite fun, I think.
But every now and then you read cases which are just crazy. I was talking to someone recently, and I was talking to another person, another lawyer, and he was telling me apparently it's far more often than you would realise how often judges need to deal with people saying that they are what is a sovereign citizen. Have you heard this term? I
have not. Sovereign citizen.
Sovereign citizen. It is an idea which is that you as a person have complete and utter sovereignty, and put simply, you didn't agree to the laws.
So you're a state within yourself?
Yes.
Like a sovereign nation has its own set of...
Spot on. So
each individual is a sovereign...
A sovereign citizen is someone who says that they are not bound by the laws for which they didn't agree with.
Right.
None of us technically agree with...
No, we're not born
We don't sign something
with a pen in our hands and agree to all the laws of the land.
No. And shockingly, judges have to deal with this idea far more often than you think.
I'm not listening to this court because it has no jurisdiction over me. How does that play out?
Well, they lose. For everyone out there, that is... it's an interesting idea as far as like ethics and values and stuff is concerned, but it has absolutely no basis. It's got no basis from what I understand under any of our laws or anything.
So just drawing on that theme, because the sovereign person sounds very similar for those out there who are going to send me 6,000 emails. It sounds very much like a flat earth concept.
It's right up there with some conspiracy
and
stuff.
The chemtrails and all that sort of bizzo. But what about the actual sovereign nations? Because there is a Lonely Planet guide to micronations. And they are micronations within a country, and it might be the size of a 600 square metre house. So what about those though? I mean, I always wonder about them, because how do they get facilities? How do they get phones put in? How do they get sewage? Stuff like that, because
presumably
they're renting it?
Do it themselves. I mean, I don't think these are necessarily in Brisbane CBD.
No.
But we know about the one in the famous ones in Western Australia.
Is it?
Which recently, I believe, he died.
Right.
There is a farm I apologise, I don't remember the name of the place.
The facts are hazy.
Western Australian sovereign nation. And for about 50, 60 years, it passed on from generation. This family who owned, I believe, a sheep farm.
Right.
Fair plot of land. Declared themselves their own country. Apparently they had their own constitution, their own currency.
Well, you need it all.
So everything, and they allowed passports. So like you could enter their country to visit, pursuant to their approval and, getting a visa of some description.
There's no visa waiver program then with this sovereign nation.
How do
they interact? Let's say a villain hops the fence and declares themselves in a non-extradition treaty zone. I mean, what happens in that situation?
Well,
do you think the police are just going to walk through it and just go, dudes, I want it back?
I wonder how much they wanted to press the issue, because we know it wasn't lawful.
I mean, what about cell phone towers?
It wasn't lawful. I know they saw themselves in that, but from all intents and purposes, they're not a sovereign nation, and there are, I believe, a whole...
This is the whole politics. I've got a lot of questions about that, because there's going to be power going into their country. There's going to be cell phone
coverage.
There'll be cell phone coverage coming from one country. There'll be water flowing from one country to another.
Yep.
I just wonder how that all works in a real way.
I suspect...
I mean, we know Monaco gets away with it, but really, what about everyone else?
I suspect Western Australia decided to take a very hands-off approach. Because you're right, they could have just, if you want to be your own country...
Yeah, I was going to cut you off.
But you're also providing legitimacy to something that is otherwise completely ludicrous. But one of the... I suppose I'll give you a chance to guess. Why do you think he came up with this sovereign nation?
Well, why did he do it?
It wasn't for principal reasons.
He didn't want to pay taxes.
Yep.
Ah!
Spot on. He apparently owed a heap of land taxes for the farm.
So no altruistic reason.
Yes, it was not at all because of his ideas about sovereignty and whether he perceived his land to be different to Australia.
It was the taxes.
He owed a lot of money, and
wow. So the ATO wasn't an issue then, I guess. What about income?
I think it was all. I think once you start going down the route of down, believing you're a sovereign nation,
it's a little
probably
bit like
breaching everything, right?
It's like all the questions you would want to ask a flat earther.
Where does it end?
Where does it all end? Where does it start? What about this? What about that? That's a well that has no bottom.
Yep. And so does the sovereignty issue, because if you are saying you're not bound by laws, and presumably you don't follow the laws you don't say you're bound to.
Yes, how would you get a driver's license?
I think they had their own.
I'm going down a rabbit hole here. Yeah, okay. So sovereign person, you have no jurisdiction over me.
You know, Your Honour, you don't actually have jurisdiction over me. And
we the people? We are not the people?
Yes. It's like a similar, there is a case which talks about someone, I think, who wanted to be called like Megatron or something. Rather than...
John?
The suspect or something like that, or the alleged, because he said that, and you
because they had negative connotations.
Yep, negative connotations, and the judge. There's a transcript, and
that's brilliant.
The judge, the person says, "I want to be called a Megatron," and the judge says, "I'm not calling you that," and it kind of goes back and forward, and I believe they let it rest for a little bit, and then it came back up. Like sort of later in the cross-examination, and the person saying, "Don't call me the alleged. I want to be called this," and the judge said, "I'm not calling you that," and it just went back and forward, just never ending. And the transcript is actually quite interesting to read.
There is another case, a high court case, where where some guy's trying to divide by 0 to prove a point. It's from years ago, but it is a fascinating. So I guess it comes up more than you think.
It's just silly stuff.
So what have you got?
Well, we have a new court.
We do.
I mean, it happened. It appeared to me to be a little bit out of the blue.
Yeah.
I was just kind of scrolling on Facebook, I think, or LinkedIn, and I sort of thought, hang on.
Thursday.
Yeah, we have a new court.
Yeah, ladies and gentlemen, Australia has a new court.
Yes, just a little bit of news. So we used to have the Federal Circuit Court, the Family Court, and Federal Court.
Right, okay.
We now have the Federal Circuit and Family Court of Australia.
That's right.
All very similar wording.
It's very nice language and very nice long name.
Very nice. So from what I can gather, they are smushing.
They're smushing the family. It's a little bit like QCAT, where they took like 120 tribunals and commissions and just stuffed them into one.
All do one.
Yeah.
So now the Federal Circuit Court, which was already doing family court matters,
is now.
But it also did general federal law stuff.
Yeah. And employment people, which is why we're talking about it today.
They've now mixed them together. So there is now this court, the Federal Circuit and Family Court of Australia, and the Federal Court.
This also means we have a whole new set of rules. We used to have the Federal Circuit Court rules, and then we have the Family Court rules, right? So now they've got the Federal Circuit and Family Court of Australia.
We're going to have to apologise that we have to refer to.
And then in brackets, Family Court division rules, and then we've got in brackets general division rules. So we actually have two sets of rules. So really, what's changed? We have no idea yet. Not really.
There is some uncertainty, but the real change, I think, is in the operations. I think it's in the way the court runs, rather than the rules.
Who does what? Like the tribunals. We've got people who used to do nurses tribunal stuff now dealing with neighbourhood fencing disputes.
Yeah.
So, do they know anything about that? Probably not. Do they have to make a decision? Yes, they do. It's an interesting space.
From what I did a bit of reading, especially in the family law sector, it's also to stop court shopping, because in the family court, you could probably get it was a bit quicker. There was a bit more resources there. It wasn't as full. So if you went through that way, you could sort of get a cleaner space.
Okay.
Because as we knew before, and for everyone out there, Federal Circuit Court, I think, would be one of the busiest
courts, guys.
And probably because of the fact that family law was in it, and it does make it significant.
But did smushing it relieve that problem?
Well, it remains to be seen. The idea is that they will now mix the resources of the family court to try and, because there was redundancies there,
can
now be transplanted across. But for example, some of their targets are quite, I think, ambitious.
Okay.
They have an aim of resolving up to 90% of cases within 12 months, which is very fast, I think.
For those of you who don't know, a family law matter might last 2 to 3 years.
I think it's up at this point.
It's probably a bit longer.
For employment matters, probably similar.
Yeah, employment matters.
Probably
If you can resolve your matter in 18 months, you're doing extremely well.
Yeah.
2 years is probably a really good yardstick. It might take slightly longer.
Yeah. And they now, though, it's very much a family court, though. So there is 77 judges, and 55 of them are family law specialist judges. And then my understanding is the remaining will still do family law, but they will also do federal law.
So it's a little bit like that song, "What about me? It isn't fair."
I think it is. I think we're getting pushed out.
I've got to say, I want my share.
And it's a very interesting space because, from what I can tell, family law is a very different arena to the other general federal law. And it seems really strange to me that we are in the same court.
Yeah, look, maybe the answer is, as practitioners, we encourage our clients to resolve their matters before they go to court. Not that we don't already try to do that in no uncertain terms, but maybe it will also encourage normal people, everyday people who start these matters to look to resolve. Because how many times do we tell somebody, oh look, if you start today, you might get a result in, this time next year, if you're lucky, maybe the year after. And they go, what?
Yeah, they're all always shocked.
What?
And to all the lawyers out there, none of this will be shocking to you because it's just the game that is. But it had me thinking, and I want you to look through the crystal ball.
Hey, crystal ball, guys, I love that.
Picture a world where we have excellently resourced courts, and it's not 12 months, it's 3 months.
You couldn't get it done in 3 months, but anyway, yes, crystal ball, guys.
Very fast, it is
just
super, super fast.
Wow, yeah.
What effect do you think that has to the way disputes are resolved?
I think people will be more willing to take it through to the end.
I think the best... I agree.
Because if you only have to wait 3 months to get a resolution and you're absolutely certain that you are going to win, and litigation is not risky, and not being the decision maker doesn't mean it's not going to go your way, all those ridiculous things that people think. I think the quicker it is, the easier it is for people to think they're going to win.
Yeah. And they don't have time to change their views.
They don't have time to change their views, and they don't have time to really assess the evidence, really stop and get into it and really think about it, and negotiate. There's no time to negotiate.
Only people that would win from that is lawyers.
Well, I'm certainly happy about all this.
Because
it goes really quick.
You would, you get to see a resolution nice and quickly, which is nice.
Yeah.
And everyone would be fighting.
All the time.
Everyone would be fighting all the time. Because I also think not only does it mean that people who could have resolved their matter choose to take it all the way.
Yeah. Because they're going to win, obviously.
Because of course, everyone thinks they're going to win.
Yeah.
But the people who weren't going to even make a dispute, they weren't even going to enter the door in the first place, now also going to start.
Because why the hell not? It'd be over in 3 months.
Be over in 3 months.
Yeah, what's 3 months?
And I'm kind of glad you kind of agree with me, because I wonder if the stress and strain of court is in of itself, although it appears to be undesirable, I don't think anyone likes it, lawyers and clients together, but I think it might be actually fundamental to our system.
Maybe. I've got this other problem with a long and lengthy system, was people get fatigued and just give up. And that's not right either. I mean, I am not professing to be any type of family law expert, but the matters that I've had some understanding of, it might be the mum's got the kid and it's the dad fight, and in the end, after 3 years, I've got absolutely fatigued and said, look, I can't do this anymore. Psychologically, I just can't push anymore. So, that's too long, but maybe this is too short.
maybe the 12 months
Where's
is just
where's our Goldilocks moment?
Mm.
Because I think you're right. Parties need a chance to learn how to resolve the issue, because we do know that a decision from a judge or a commissioner doesn't actually settle either party's minds.
No.
We know that conciliated decisions make people happier.
Yeah.
Even if they're unhappy, they are happier than they would be if a decision was handed down.
Because with any decision,
It's taken out of your hands.
it's taken out of your hands, and generally, at best, one person wins, one person loses. But quite often we see both lose.
Both lose. Even
Both
if you might get your unfair dismissal, but your payment will be so nominal that it didn't make it any sense to live in that sort of environment for that long. So I think there's a Goldilocks moment. I think it's too short. We've got little bear going, ooh, it's too cold.
And the 2 years, too long.
It's just fatiguing, and it is inevitably more expensive.
Yeah.
I think the parties need a chance to learn how to resolve. Really, they do. They need to learn how to find their happy place in amongst all this and get a solution.
So, put your Attorney General shoes on, and again, crystal ball, like you've got all the money in the world, which we know they don't. But
No.
Are you saying, well, despite the fact that we can do it in 3 months, I don't want it to be done in 3 months?
Well, I think we need to look at the process. For a start, we know there's an application and then there's a response. You need to provide the respondent time to put the response together, and that's a month, and I think that's fine. And then we have the period of disclosure and affidavits, and it takes 2 weeks to draft an affidavit, and it takes 2 weeks to draft an affidavit in response to that, and it takes another 2 weeks to draft an affidavit in reply. So, and now we've got mediation, and the parties have to look at all this material and really digest it, and then turn up to mediation and have all of that happening, and now think about what's going on. And what are we talking about now? We've got 4 weeks, and then we've got 2, 4, 6. So we're at mediation almost at month 3 already. So what I would say is, if I had all the money in the world, I would look at the process, say how long it takes to get something done, court manager, because you've got money, right? You can bring them into court and case manage this.
Yeah, there's also some mentions in there because we've got money.
Yep, case manage. What we mean by case manage is have a judge tell us what dates in the process is going to be. On this date you're doing this, on this date you're doing that, on this date you're doing this. After this date everyone's coming back, we're going to see how everyone's going. Yeah. It's expensive, but it works. So I would case manage it and figure out how long that case management takes, and then say that's a reasonable time. But it's not 3 months.
But
Lots
even
of
then,
solicitors that need to stop and look at this, and this is not the only thing we're doing.
But even then, even if we reduce it to the minimum you possibly can, which is probably 4 or 5 months.
I'd say 6, but yeah, I like 6.
Are you still taking into account, do you almost in the guidelines allow for time, because time we know will likely lead to
resolution?
I
don't know, but don't
almost like
don't people need a breath as well? If they're running for 6 months,
they're not thinking about resolving.
I mean, how are they gonna get to a hearing and go best foot forward? Where's the holiday in this? If you were working 80-hour weeks for 6 months, you're going to be really fatigued. So I don't know. There's no good answer here, though.
There probably isn't. I mean, we're talking fantasy land here, because, as I mentioned, I think the 1 year goal is ambitious. I'd be really happy to see it resolve and be better, because
family matters within 1 year. It's amazing.
All matters, including
all those entrenched views. Okay.
But I mean, even as lawyers, we'd like to see it, improve a little bit.
Yeah.
And we're cognizant for the struggles that are going on.
We would have happier clients if they knew their matters would be resolved quicker than what we tell them.
Yeah.
we would actually have happier clients.
And it is sometimes frustrating to see someone who might have a fairly decent claim and feels fairly hard done by, and they just can't go through. We tell them
do the next thing.
we can't. We tell them that it might be 2 years.
Yeah.
It's a good, as you said, a good thumb suck, and a lot of people aren't, irrespective of whether they have a good claim or not, just can't do that.
No, because they're looking into their future going, I might have 4 children by then. Are you kidding? Yeah.
Gee, it's a long contract.
It's a long contract.
It's hard to get an employee.
You're
to work
indentured for 2 years. It is very difficult. Well, people, it's been a very legal lawcast
very legal
today.
lawcast. Very
legal lawcast today. I guess in 2 weeks' time we come back.
Yeah.
See how the federal circuit.
I hope by then I know it off by heart and I don't need to read from
That's
it.
right.
The Federal Circuit and Family Court of Australia.
Goes, and maybe there'll be another rather theatrical case.
Spicy case.
Yeah, very interesting, people. Hope you enjoyed today's.
Yeah.
If you want to talk about the cases or you want to find out a little bit more about what they are, send us something and we'll send you the citations.
Yeah,
you can read it
perfect.
for yourself.
See ya.
Thanks for watching.